good to go.
All good? All right, Ken, just to start, in case somebody else gets their hands on this, can you say and spell your first and last name for me, please?
Sure. It's Ken Irvin, K-E-N, last name E-R-V-I-N.
Okay, and Ken, you are the attorney for Christopher Taylor.
One of two attorneys.
One of two attorneys. Just give me your reaction to, well, first of all, how did you hear about the grand jury's decision?
I got a call this morning from Dexter Guilford. He's the head of the Civil Rights Division at the District Attorney's Office, the unit that handles prosecution of use of force cases for police officers. He called me and let me know that they had gone back to grand jury and that this time they returned no bill, declined to indict for any crime of including murder or anything less that was presented to them.
Did you know they were going to go back to the grand jury?
No, and I would have appreciated that ahead of time so that we could prepare materials for the grand jury or potentially have Officer Taylor testify for the grand jury, but no, not given notice.
So because of that, you all had no involvement with this grand jury proceeding?
None, correct.
What did you think, A, when you heard that they'd gone back, and B, the result?
Surprised, and not surprised because they should move forward, but just surprised that they seem ready to die on that hill. We tried twice to have a trial in this case. We had one mistrial after jury selection, and then we finished evidence, closing arguments, and the jury couldn't make up their mind. So it was a hung jury, 8 voting not guilty, 4 voting guilty. And at the time, or shortly thereafter, DA Garza did publicly state that he was going to try this case again. So that was all that we heard. We were preparing for trial again in September, potentially, and no, very surprised.
As you said in your statement, they could have used the original indictment. The original indictment was still good for murder, even though there had been these mistrials. How common is this to go back with, I guess, new charges, or to go back to the grand jury a second time?
It's common if new evidence comes to light. And maybe a person is arrested and they're initially indicted for something, but more information comes to light. You go back and seek another appropriate charge. That's not the case here. The evidence has been what it has been for 4 years. There hasn't been anything new. So there was no legitimate reason to go back to a grand jury. They did have a valid pending murder indictment. They can proceed on that, and they can still proceed on that today. So the only reason to go back to grand jury was to get this next grand jury to decline to issue any indictments. And then you blame that grand jury and say, well, the second grand jury declined to indict, so we have to dismiss the case. That is incorrect, and it's a bit of smoke and mirrors, and it's political cover. It's our district attorney not taking the responsibility that he has for dismissing the case and explaining to the public why he's doing it, which is there was no crime and he can't prove there's a crime.
Why do you believe that's the case here? Why do you believe that's the motivation?
Because there was no other reason to go back to grand jury. No new charges, no substantial new charges can be added. There was no point. There's already this indictment that they can proceed on. So there's nothing to obtain from this new grand jury if you were going to move forward. Now, if you did not want to move forward, but you didn't want to take the heat for dismissing the case, then this is what you do. You go back to grand jury, you control what they see and hear, you get them to issue a no bill or a declination of charges, and then you blame them for not being able to proceed. That's why I'm convinced that that's exactly what happened here.
If there had been new evidence in this case, you would have been notified about it, right?
Well, I should have been. This DA's office has a little history of not notifying us of evidence. In fact, a court order on my wall back there where the DA's office was ordered to pay myself and co-counsel Doug O'Connell some of our attorney's fees because we had to go out and collect evidence that the DA's office should have turned over to us.
Have you spoken to DA Garza since this decision?
I've spoken to him only a couple of times when he was campaigning and I didn't know who he was. But no, I think he's got zero interest in talking to me or Mr. O'Connell.
He says, in a statement, he said that this is the end of the prosecution in this case. Do you believe that?
You'll see. Not necessarily. So the DA's office, they can't just dismiss a case on their own. They have to file a motion to dismiss and give it to the judge for consideration. And the judge if the judge wants to, can then sign an order dismissing the case. But it's up to the judge, and it's discretionary. The judge doesn't have to sign that. One option we do have is to ask the judge not to sign the dismissal order and force the DA's office to try to prove their case, or to have, essentially a fake trial where the judge calls the case for trial, DA's office doesn't present any evidence, and then at that point we're entitled to an acquittal. So we may be seeking an outright acquittal, which is a judgment of not guilty, rather than accepting the DA's very late motion to dismiss.
And what's the timeline for deciding which one of those steps happen next?
Well, it's a little bit up to the DA's office. They have to file their motion to dismiss, which I'm told will happen probably sometime next week. And then we just have to let the judge know, we don't necessarily want her to sign it, that we want a hearing on the state's motion where we will make our arguments as to why or why not she should grant that dismissal order.
I know you're also representing Mr. Taylor in this case from 2019, the De Silva case. That murder charge is still pending, right?
Still pending, right. So we're scheduled for a trial in September, and we are waiting on the judge to tell us whether we're going to go to trial again for the third time on Ramos or the De Silva case. We've asked to go to trial on the De Silva case. So if the Ramos murder charge goes away, then all we have left is De Silva, and we are assuming at this point and preparing for trial in September, although I will not be surprised if our DA does the exact same thing, pulls the little trick of going back to grand jury and then blaming them for dismissing the case.
You don't think that he has the evidence to get a conviction in that case either?
Absolutely not.
Can you remind us, I guess, about both cases? We can start with De Silva and then go to the Ramos case, why you believe your client is innocent.
Sure. Policing is a dangerous profession. They wear a bulletproof vest to work. They carry a firearm, sometimes multiple firearms, multiple tools to deal with the public, deal with dangerous individuals. In both of these cases, Officer Taylor, but not only Officer Taylor, other officers were faced with deadly threats. For Ramos' case, it was a vehicle that was driving toward police officers. In the De Silva case, it is Mr. De Silva wielding a knife and moving toward officers in a threatening fashion just a few feet away. And when you have situations like this, not only officers, but anybody is entitled to use deadly force in self-defense. So in both of the cases, the overwhelming evidence is this was a justified use of force. It unfortunately did result in the deaths of 2 individuals, but justified under the law.
In the Ramos case, from just the body camera video, it appears that the car is driving away from Mr. Taylor, but I guess his assertion is he was worried that the car was going to hit other officers. Can you expand upon that a little bit?
Sure. So we spent a lot of time on that in trial, and we brought in a professor, an expert in visual perception and cognition. One component of it is Officer Taylor, his role is to hold a rifle, it's called lethal cover, and hold that on Mr. Ramos in the event he places somebody in immediate danger of serious bodily injury or death. Now when Mr. Ramos starts to drive, the footage very clearly shows he does drive forward. He does drive toward police officers. It was at that time Officer Taylor makes his decision to shoot, and then there's always slight little delays, little gaps between making a decision and then taking an action. While this is occurring, Officer Taylor is looking through an optic, right, a small piece of the world, and nothing else is visible to him. And so as Mr. Ramos is driving forward, any sort of turning left or right or variation is not perceptible to a person standing where Officer Taylor was. And again, he's just looking at Mr. Ramos's body, and nobody is able to perceive the direction of the car under those circumstances. So evidence show it did turn right at some point, but that was after it was headed toward officers and after Officer Taylor decided to use force.
And going back to the decision by the grand jury, how did Officer Taylor learn about it, and can you talk about his reaction?
It was the first phone call I made after hearing from Mr. Guilford at the DA's office. So this has been over 4 years now, and that's a lot to process for anybody, and particularly a police officer in such a high-profile trial. So Immediate reaction, I think, is fair to say some amount of relief, but some amount of resentment as well. That it has taken 4 years to get to this point, and right, while we believe this case never should have been indicted, it was. But if it was going to be dismissed after the hung jury, then it should have been dismissed after the hung jury now 8 months ago. So why wait 8 months and make him undergo this if this is what you were going to do?
What have the last 4 years been like for your client?
He's honestly, he's probably stronger than I would be. He knows what he did, although didn't want to do it, was part of the job, was prepared to do it and did do it, and potentially saved other officers' lives. I mean, we don't know what would have happened if he hadn't used deadly force at the time. So he's always been confident that what he did was appropriate under the circumstances, not only legal, but perfectly in accordance with training, which in the trial came out, through officers with the department, training officers. Everything was in accordance with policy. So if you do what you are trained to do, what you were supposed to do, and you do it within the bounds of the law, then I think it's a little easier to have some confidence that this will happen, that eventually you will get through it and cleared.
Where's Officer Taylor today?
He is working for the department, so he is still with the APD. He is on paid administrative duty, so he is working not necessarily in a handcuff street patrol capacity, but is working, contributing to the department.
And I believe you told me this afternoon he's spending time with his family?
Correct.
Okay. I know he's not here for an interview today. Does he plan to speak with the media about, share his side of things, and if so, when will that be?
We've had those discussions, and it's a maybe. We do, at the moment, still have this pending De Silva murder case. We may or may not advise him to talk to the media at this time. Once that case, I think, will be dismissed. And if it's not, then once we get an acquittal, then those barriers to talking are lifted, and he may be very willing to talk.
But are you saying that before he talks, you'll want a resolution on the De Silva case?
That's preferable, yes.
Okay. And then we were talking before we started rolling here, there's still some civil litigation against him as well?
There is, yeah. So I don't represent anybody in the civil cases. I'm just defending Officer Taylor in the criminal. But yes, we do, Mr. O'Connell and I do work with Officer Taylor's civil attorneys in the civil suit.
Okay. I don't imagine, you probably haven't had any contact with the Ramos family or their attorneys?
Rare. We've been in contact with one or two attorneys for the Ramos family intermittently, but there's not a big role for us as the criminal defense attorneys over in that civil lawsuit world.
Gotcha. I guess just to wrap up, Ken, just next steps.
Next steps are deciding whether we're going to accept this dismissal or we are going to ask for an acquittal. And that's ultimately going to be up to our client, with our advice. But when you indict somebody and you try them twice and it's been 4 years later, sometimes a dismissal might not be enough. You want your name cleared. You want a judgment of acquittal. You want a pronouncement from a court that you are not guilty of this offense. And we may insist on that.
Ken, what else?
Mostly just disappointed with our elected DA. That again, he is using the grand jury for purposes that it's not intended for. There was no reason to go back to a grand jury at all, other than to have somebody else to blame. And it's tremendously disappointing. He's an elected official. He is charged with making tough decisions. This is literally in his job description. And if he needs to make the tough decision for him, that it is appropriate to dismiss this case, he needs to own it. He needs to sign that dismissal, and he needs to say he made that decision, not issue a press release blaming grand jury.
Jake, do you have any questions?
No, I think we're good.
Yeah, I think we covered everything. So,
Cool.
cool. We'll just get some cutaway